Good morning. Good morning. Happy Thursday. It is September 26th. Today we are in court for New Mexico versus Hannah Gutierrez on her post-trial defense motion to dismiss her case. So her defense attorney is saying, Your Honor, you dismissed the Baldwin case. Can we get some of that dismissal? and can we get some of that dismissal? And will you let her out of prison? So that is what we are covering today. This is all being held by Google Meet. We will see how much patience the judge has for Carrie Morrissey. Carrie went on and on in her motions about how Bowles was, bringing these motions prematurely and how until anything's decided, she's not getting out of custody and all of the procedural stuff. But we will see what happens. So I can't wait to get into this hearing today because there's been so much going on with Judge Summer and Carrie Morrissey and all of the meltdown motions. So Bowles, though, didn't bring a ton of supportive law, and he didn't make clear how what happened in Baldwin's case really impacts Hannah, because Hannah knew that the rounds, like Teskey went to Hannah and her lawyer and showed them the rounds. And then they were like, we're not calling you. And then he went and dropped them at Santa Fe Sheriff's. And then those did not get shown to Baldwin's lawyers, but they were shown to Hannah's lawyers. So the cases are not the same as to Bowles and Hannah as they are to Baldwin and his lawyers. Different positions. So we are going to get into this. Vicky, I always do everything on a delay. So yes, most hearings will start before I start. I do almost every case on a little bit of a delay to give me time. And because I want to zoom if they all take a break at some point. And that is the best for me. That's why I appreciate no spoilers. Just a reminder, spoilers will be yeeted from the chat. The mods know that because A, it's difficult, and B, a lot of the law nerds want to watch along with the law nerds. I know there's lots of breaking news today. We may or may not cover new indictments in New York. I don't know if I will. I don't cover politics. All of you in Florida, I hope your power stays on, that there is minimal damage and that everything is fine. Batten the hatches, shutter the storm shutters. And for those of you waiting for Metallica tickets that pre-saled today, pre-sale wasn't that bad. I'm very excited to have gotten Metallica tickets first thing this morning. So if any of you are as excited as I am about the 2-night situation, I kind of love that they're like, you get 2 nights of tickets or you get nothing. That's just what you get. Some of those tickets, you guys, some of those tickets were like $10,000 a seat. I was like, no, like, no. This is not the Dave Matthews Band. There are some experiences I will pay for, but I literally could not. But I'm very excited. Though tickets are not inexpensive, at least I'm not buying them on resale on top of resale on top of resale. And Titan Stadium, Nissan Stadium uses SeatGeek, not Ticketmaster. So I feel like it was a win all the way around today. I mean, I will say the $10,000 a seat involved like a whole bunch of other stuff. Like there was like a meet and greet beforehand and like swag, and you get like a platform thing. Like they're doing a whole in the round tour. It's a whole situation. But those were like curated experiences. It wasn't like just some seat in the stadium. It was a whole thing. But they're doing a really interesting stage setup. I can't wait to see how it happens. Deb, I've never seen Metallica live. Emily, why? Do you spend all of your money going to the Dave Matthews Band? Maybe. But some of the tickets for the 2 nights, I think they were starting at $200, $300. But still, that means it's like $150 a night plus fees. It is not inexpensive. But the $10K a ticket, I mean, what, $5K a night? I guess. I wonder how much they're selling suites for. If they're selling the, anyway, wild. That's definitely not what we did, but I'm ready. I've never seen Metallica. It's one of the bands that's on, like, if they go on tour, we're doing it. And the great thing about Nashville is live music comes to Nashville, and I love live music. All right, y'all. But you know what I also love? I love going to court with the law nerds. I feel like today's a good court day. For those of you that are tuning in for part 1 of court day, I think we're going to end up part 2 of court day as well, because there's a Kohberger hearing happening with the new judge. And there's a lot of like discovery stuff going on in Idaho. And I want to see what the new judge has to say. Like, we need to go figure out the vibes. So we're going to go to Kohberger this afternoon. We're going to take a lunch break in the middle because Kohberger is not till about 2 p.m. Central. So we will also pick up an afternoon stream. We'll let you know in the app. Now's a good time if you've got to take a break too. If you're like me and you're going to get sucked into doing other stuff or playing casual mobile games, sorry, not sorry if you've been playing hours and hours of Midas Merge. But if you're going to be playing casual mobile games, you might want to make sure that you download the Law Nerd app so that you can just be pinged and notified that it's time to come back to court this afternoon. So I'm very excited. It's time to go to court. I'm going to roll the intro. I'm ready for some fiery sass. I might be sad if there's not sass. Like, I'm expecting sass today. I'm ready for it. Like, my face is being sassy with me. I'm still sweating from my workout this morning. Like, I'm ready for sass. Are you ready for sass? Let me know. Law Nerds, let's ride.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Law Nerds unite to talk about facts, not... Let's get into it.
Let's go to court. It's live court. It's live court. The judge is just calling the case. I love that New Mexico puts all of their Google Meet hearings public. I think it's fantastic. Let's get right into court, shall we?
State of New Mexico versus Hannah Gutierrez. Party state their name.
Oh, I forgot my notebook.
Carrie Morrissey on behalf of the state of New Mexico.
Good morning, Your Honor. Jason Bowles from Ms. Gutierrez.
You guys. A, my closed caption moved. How rude. B, I'm going to gain this audio up. C, Bowles got a new painting, or he's in a different room in his office or something. Because that's not the painting with the steeple that looked like it was a hat on his head. I am shocked. Hat head. The little steeple. He had that like little red steeple. Full new painting. Jump scare. Okay, let me get this audio right real quick. Because it's
Let's see.
Fighting with me.
All right.
And then I will pull it back up on screen. Don't worry.
We should do is start with the second motion, the more substantive motion, and then go into the other motion.
That sounds good, Your Honor. All right, let's back up just a bit as I jump scared myself with Bowles' new painting. Carrie's walls are like the color of the courtroom. That courtroom color made everybody look kind of yellow. Like the white balance on the cameras were like, we could never. Okay, sure. She's just blending. I need to just, you know how everybody who is online for a period of time is like, I'm going to sell a course on a thing. I mean, maybe that's very 2019, but I'm going to just charge lawyers to help them make their Zoom background better. Just that I need to do that.
Of New Mexico.
Good morning, Your Honor. Jason Bowles from Ms. Gutierrez Reed.
I like the new painting. It does appear crooked, but I like the new painting.
Let's see.
I don't like.
All right. So what I think we should do is start with the second motion, the more substantive motion, and then go into the other motion.
Yes, Your Honor.
All right.
It just
prepared. Go ahead.
to stay.
Thank you, Your Honor. And so just to clarify, Judge, you want me to argue the motion for new trial?
Chat, I'm going to shift the screen a little bit. I think that maintaining visibility on the closed caption is more important than maybe seeing all of Bowles' head full screen. So that's the choice I'm making.
Or for dismissal first?
Because it will not stay.
No, not the release one. Okay.
Yeah, okay. Yes, Your Honor. That's what
dismissal.
I said. Okay.
Okay.
Thank you, Judge. Judge, on July 31st, 2024 of this year, this court filed an opinion.
I'm going to summarize in advance. Your Honor, Carrie Morrissey lied to this court in the Baldwin case, and you dismissed his case. Dismiss our case. There will be more, but in some.
In the Baldwin case, and this followed a July 12th hearing in that case. In paragraphs 59 and 60, this court went through the findings of the state's egregious discovery violations, deliberate and intentional withholding of evidence, and in the court's inherent power, stated that dismissal with prejudice was warranted to ensure the integrity of the judicial system. Now,
Using the court's
part of the
words.
court's findings, and I'm going to relate them to this case,
The court's
part of the
words.
court's findings also included that Ms. Morrissey, when she testified, called herself as a witness in that hearing on July 12th. Her testimony was inconsistent
What did I
internally.
say?
Her testimony also conflicted with at least one other witness. Now, we have since supplied this court with affidavits from her former co-counsel, Erlinda Johnson, to highlight additional, we believe, false testimony that Ms. Morrissey gave to the court. Now, that's important because I think this court has to view through the prism
Your Honor.
of the prior findings of the affidavits, the comments Ms. Morrissey is making, and what I consider to be shade on the truth on her state.
He's going a very long distance to not directly calling her like liar, liar, pants on fire. A shade on the truth is a very interesting way to say that. But what he wants to say is liar, liar, pants on fire. What's interesting is this is the first time we're going to hear Carrie argue against this in court because it's all been in writing with the Erlinda Johnson of it all. That was all in Baldwin's motions. We know they have a mutual defense agreement. That means that the defense attorneys can share information. That's something that has to be agreed to by both defendants. In this case, it makes sense. But bringing in the shade to the truth is a really interesting way to say it.
Statements. Now, part of the court's findings at paragraph 10 in Baldwin's case included that the state had continuously made late
Using the court's
disclosures
words.
and that the state had filed a certification, specifically Ms. Morrissey had certified that she had supplied all of the evidence required under the rules under
She shouldn't have called herself as a
5-501.
witness. It's crazy.
Now, that same thing occurred in this case. And Your Honor, post-trial, we have now learned that Ms. Morrissey never disclosed to us, and I'm going to get into these and why they're
The
important.
Hague reports.
The Hague report from
Hague.
August 31st, the Seth Kinney interview that I've highlighted in the
Oh,
motion.
that's right. I forgot about that.
And the third one are these Teskey rounds. And I'm going to explain that in a little.
Sir, you had the Teskey rounds. But as to the interview, I had forgotten about that. As to the Seth Kinney interview, 100% a problem to not turn over the Seth Kinney interview. And as to the Hague report, 100% a problem. And these were discovery violations that were found in the Baldwin case as well. And so I think those have a little more meat on the bones than these rounds. These rounds are not it. But the video on the Seth Kinney interview, and again, the judge would have reviewed this motion last night. Emily, did you do that? No, I have company coming. I was washing sheets. But the judge would have reviewed these last night before this case. But I really appreciate that he's like, just so you remember where we're at, Your Honor, it's this and this and that. Because we haven't looked at this in a few. So I appreciate the summary from
little more
Bowles.
detail as well. Now, the same thing the court found in paragraph 10 applies here. The state made that certification and it was untrue. Your Honor also found in paragraphs 27 and 28 that officer that CST Popple that testified in Ms. Gutierrez Reed trial had lied, had given false testimony in Baldwin's trial. Specifically,
That
there was
happened after
a
your trial.
interchange between Ms. Morrissey and Ms. Popple, in which the idea came up in testimony before the jury that these rounds were not similar. The Teskey rounds were not similar to the rounds found in the rest set. The court then held a hearing on July 12th and actually ordered those rounds produced. And despite Ms. Morrissey's continued assertions to me, to the jury, and also part of her testimony that they were not similar, there were three very similar or identical rounds, Starline brass, with silver primers. Now, as part of that aftermath, Corporal Hancock testified that Ms. Morrissey was part of the meeting to what I consider to be bury and hide the Teskey rounds that were turned in on March 6th
Carrie's going to be sitting
in a
there like,
separate case file under a separate
that's
number.
not what happened.
Now, Ms. Morrissey stated that the first time she saw these rounds was July 12th. Then the court asked a question during that hearing to Corporal Hancock. Corporal, was Ms. Morrissey present in the meeting to put
Sorry,
those
that's
rounds
me.
in a
Hold on.
different case file under a different number? And she said, yes, she was.
If that froze, it was me.
Well, and that's part of the court's findings in this court's order, that Miss Morrissey was part of the decision to hide those rounds, hide the supplemental report,
And we know what
to not
Carrie's
have
going to
that
say,
produced. Now, in
Your
Mr.
Honor, I'm not
Baldwin's
law
case,
enforcement.
the standard,
I don't
and
work for
as
the
this court
sheriffs.
notes in paragraph 48, was evidence disclosed within a trial. Ours is obviously the standard post-trial. And so this court delineates that standard and how it's different for post-trial discovery of evidence. Now, that is that we have to show that there was a reasonable probability that the outcome would be different. And I'm going to get into that with each of our
This is the standard.
pieces of evidence.
So Bowles' burden is to show a reasonable probability that the jury would have come to a different conclusion. This is a difficult burden for him because, again, I think some of the most compelling testimony against Hannah Gutierrez is her interview where she's sitting there with him at the police department saying, I should have checked the guns more. Will any of this stuff change the outcome of Hannah's own words? So if you were ever curious about when it's a good idea to go in and try to help, remind yourself, helping doesn't help. Even when you have your lawyer there, her sitting there going, I should have checked it more, is the most compelling evidence that she didn't do her job accurately, adequately, or sufficiently. And that's how you end up with this, entire trial and with the negligent homicide. It's the not doing your job adequately with a foreseeable consequence. So it's a different thing. Loki in the chat asked a great question. Loki said, so if Baldwin had said the same, Baldwin is different. The standard is different during trial than after trial. We can have a very long discussion at another time about the propriety of the standard during trial and after trial being different. But the standard during trial and after trial is different. So Baldwin did not have to show the outcome would be different. Hannah has to show the outcome would be different. And that's where Bowles is going to have to convince the court that the outcome at trial would have been different.
Judge, the fact of the matter is, we would have never discovered the Teskey supplemental report or what they had done with that.
And that's the problem.
If Baldwin's case had not occurred,
And
if
that's
they
the
had
problem.
not done those interviews,
They would have never known about that.
We would have also not discovered the Hague August 31st report, because those came out in Baldwin's interviews in that subsequent case. Those were never turned over, as was Seth Kinney's. So they were all suppressed. Now, were they favorable? The court finds, as part of its order,
This is the standard.
July 31st order,
this is the court's words.
that there the defense had outlined a progressive trail of how the rounds got from Troy Teskey to the set of rust. And that was in paragraph 30 of this court's order. The court went through how they went from Teskey to Seth Kinney. They went to the 1883 set and how they ended up on October 12th being given to Sarah Zachary.
Right.
Now, the court also said that any additional information as to the source of live rounds or how they arrived on set would likely affect the jury's determination as to proximate cause and as to negligence of third parties under 14-251 UJI.
Sir,
Now, it is the same thing.
the third party's in the room with us, though. As to Baldwin, the third party is your client and Dave Hall's. But I wonder if he is saying that the third party here is going to be Seth Kinney. I'm interested where he's going to go.
In Miss Gutierrez Reed's case, but the facts are different. The reason why the facts are different are that Miss Morrissey, in effect, suppressed them in our case by telling Mr. Teskey she would retrieve these. She told him in his pretrial interview, and that's detailed in our motion, that she would retrieve these and the state was going to collect them. Now, that never happened. But by telling Mr. Teskey that, Mr. Teskey didn't want to do anything with those rounds. He didn't want to touch them, and he wanted to keep them secure and safe. Now, I was not able to see those rounds until the second to last day of trial was the first time I saw them. Mr. Teskey didn't want to bring them. He didn't.
Second to last day of trial.
Didn't want to be accused of tampering or obstruction, and I didn't want to, and Ms. Morrissey said I didn't want the evidence. She, again, shades the truth. The fact of the matter is I didn't want to be in the chain of custody, nor did I want there to be any allegation
That's fair.
that I had anything to do with something nefarious with regard to those rounds. So I directed Troy Teskey to turn those into the sheriff, which he did, because we wanted law enforcement to have them.
That's
because
fair.
at that naively,
Don't come hand
the
me the
state would do
bullets.
the right thing and would test them.
He didn't say
Never
whether
in a
he'd seen them or
million
not.
years did I think the state was going to hide those in a separate file under a separate case number, which then came out in the Baldwin trial.
But you saw them the second to last day of trial, and Teskey didn't go turn those in until after closing arguments.
So that's what Mr. Teskey did. He turned those into the state. In the aftermath of that, we weren't told what happened. We weren't told there was a separate file. We weren't told any of that. Because Ms. Morrissey basically held those in place with Mr. Teskey, it's the same thing as the court found in the Baldwin case. We weren't able to test those. We weren't able to utilize those rounds. We weren't able to even touch them because the state was going to seize them. Now, had we been able to use them, it goes back to the court's paragraph 30 on outlining the trail of how the live rounds got on set and how they got on the
Chat, thank you for the weather updates. I know. KMM, thank you. Tomorrow's the homecoming football game here in Nashville. And so, yes, I am keeping an eye on my favorite weatherman of the internet, Ryan Hall, y'all. So I will keep you guys informed, but not about the weather while we're doing this, because technically it does count as breaking news, and it also will absolutely distract me, and I will start talking about the weather, which I know very little about other than watching Ryan Hall, y'all, and looking out my window. But we'll link that at the end of the stream if you guys haven't found that channel yet and want fantastic weather coverage in a prepared, not scared type of a way. He is the best to do it. So let us continue on.
The hands of Mr. Kinney and got to Rust. The state's theory at trial against Ms. Gutierrez-Reed was based on a series of pictures that they put together that Ms. Gutierrez-Reed must have introduced the live rounds because here's the pictures. Well, in reality, now that we learn that Mr. Kinney could have introduced those on October 12th through Sarah Zachary.
It's always fucking Seth Kinney.
And the jury could have been shown and seen those rounds. I asked the state repeatedly to test them, and they did. They would not, even though they tested every other piece of evidence in this case, except the live.
Do you stream too? If you do, I apologize. We've always got meteorologist D. Cortez in the chat. So we have the things. If this, I don't know if this is your YouTube channel. D, I apologize. I should go check. That is completely my bad.
Rounds. They didn't test those for DNA and fingerprints, but they didn't test the Teskey rounds. They refused to. Your Honor, second, as to the Hague report, I think this is very critical. The Hague report and the one we're talking about, this is one that we never got during trial. Mr. Hague, the state's chief expert as to the firearms, made a report that says it seems unlikely, although it cannot be excluded, that these tool marks on the firearm are the result of the damage incurred during the FBI's impact testing.
The weapon potentially having tool marking different for Baldwin, not a serve when it is your client's job. So when it's your client's job to check the gun, you know? So I don't know if it helps if but Your Honor, the gun could have been damaged. Well, it's your client's job to check the gun. I'm going to start singing Chicago.
He goes on to say that they do not appear to be original manufacturing marks or use and abuse tool marks. Now, then he follows with these tool marks are unlikely to have had any bearing on the operation of the revolver at the time of the incident based on the FBI's trigger pull data. However, the fact that he made the comments that they seem unlikely to have occurred during the FBI's impact testing and not consistent with original markings, we could have used that at the trial. And in fact, Your Honor, what's even more important is I asked Mr. Hague on the stand a very open-ended question. My question was,
a lot of them were.
Did you see any other evidence of modification or damage to that firearm other than what the FBI's testing did? He said, no, sir. Now, Ms. Morrissey tries to again spin that by saying that was in the context of the functionality of the firearm. I did not include the word functionality in that question. was a very open-ended question. Mr. Haig said, no, sir. When in reality, both Ms. Morrissey and Mr. Haig knew at that time he had authored a report that showing that there was other damage to the trigger and to the sear. Now, later on, Ms. Morrissey points out in a response, after Hannah's trial, Mr. Haig is able to learn more about the firearm, and then he's able to change his conclusion. But at the time of the trial, Mr. Haig had a report saying there were unexplained tool marks and on the trigger and sear, and they weren't explained by the FBI's testing or the original manufacturer. Your Honor, we would have used that in the questioning and potentially raised an issue in the jury's mind regarding that jury instruction 14251.
It would have raised a question in the jury's mind regarding why didn't your client make sure the guns were working properly? That's all.
Which is critical in this case. The jury sent out a question on that jury instruction. And that is, was this an uninterrupted chain of events? Or did something occur that interrupted the chain of events?
That's a good point.
That would have been a proximate cause issue. If there was damage to the trigger sear, and we're able to cross-examine Mr. Haig on that, the jury doesn't have to believe his conclusion that this didn't affect the functionality. They don't have to believe that. And again, this goes back to Ms. Morrissey, who stated to this court repeatedly, certain items of evidence are not relevant. And it's her determination. She did things because they're not relevant. But that's not her call. That's not her call under the standard, under Brady and under exculpatory evidence.
That's not her call at all.
Because the defense may have a different use for them. I guarantee I would have altered my strategy at trial, as the court said in the Allison case. And that case is where the court reversed a conviction of a defendant's arrest record that wasn't disclosed to him. Obviously, he knew about that arrest record. But the court said it could have altered strategy of the defense at trial had we known about they were going to use it. Well, the same thing is here. If I had known about the report, we would have highlighted that, and we would have made a strong argument under 14251. You can't be sure as jurors that this didn't affect it because we have a report here showing from Mr. Haig there was damage that he can't explain, and he was a very important witness in this case. It's inexplicable that we didn't have this report. And Ms. Morrissey this trial ended March 6th. It was August 31st that Ms. Morrissey first indicated in an email that this report would be turned over, and it was her failure.
And I think that report, as a footnote, was found because of Erlinda's search. When Morrissey told Erlinda not to search, I think this is one of the reports that was unearthed in all of that.
Why it didn't get turned over. There wasn't a very good explanation. There is no good explanation for not turning that report over that we could have made use of. The other thing that's critical to understand is this was coming out during the Baldwin interviews, which was going on simultaneously as we were having our trial. So it's just inexplicable that Ms. Morrissey would have hidden this evidence for use in our trial. And Your Honor, finally, the Seth Kenney interview, that interview had several things, and this interview was suppressed. I would have crossed him on several of the statements. Now, Ms. Morrissey's comment is that we knew about these other items through other witnesses. That's kind of the general statement she's made in response. The facts of the matter, however, is that Ms. Morrissey vouched for Mr. Kenney improperly in closing arguments, saying he was, in essence, anybody that disagreed with what he said was lying, and basically that Mr. Kenney was telling the truth. So it would have been very effective for us to be able at trial to have used Mr. Kenney's own words in this interview that we did not get to cross him on statements he had made. So that is the import of that as to impeachment. These items are material. They are favorable. And Your Honor, I think the most significant thing that came out of the Baldwin hearing, and this court appropriately and was warranted, dismissed that case with prejudice.
Lots of you are asking, why didn't we see this Bowles in trial? Motion argument and trial is very different. He seems imminently more comfortable arguing motions. And we saw him arguing motions like this when we were in the pretrial. We also saw the judge be much more decisive in the pretrial. We did not we did not see the same judge during trial. So there are times if attorneys do a ton of motion argument and not as much jury work, then that can be a reason. Also, remember, Bullion somehow left in the middle of trial. So whatever Bowles was doing in trial got completely upended. So there's a lot of potentiality there, but I've seen lawyers be very good in motion in front of the judge and not as great in front of a jury. But he also has a better argument here than he had at trial. He has good arguments here because of what Morrissey did. These arguments don't come up if Morrissey didn't do the stuff. Morrissey did the stuff. And he's also got his notes right in front of him. So he's linearly going through this and this and this and this and this. So it is a different type of argument.
Because of the egregious and continuing pattern of discovery misconduct, and it didn't just start after Hannah Gutierrez Reed's case. That's not, they didn't conduct themselves ethically and then all of a sudden unethically in that case. This pattern of discovery abuse occurred in Ms. Gutierrez Reed's case in the same manner as it did in Mr. Baldwin's case. And because of that, we're asking the court to consider dismissal in this court's inherent power, and the court lays out in its order the court's inherent power to issue a whole host of sanctions, or in the alternative, a new trial, Your Honor, because it's the significance of the items that were suppressed, favorable and material to Ms. Gutierrez Reed that could have been used. We also have a situation, Your Honor, where I'm going to ask the court to order in this court's inherent power, if this court orders a new trial, to remove Ms. Morrissey.
That's an interesting argument. I don't know if a new trial helps your client, but I want a new trial and I want Morrissey out.
We also have a situation, Your Honor, where I'm going to ask the court to order in this court's inherent power, if this court orders a new trial, to remove Ms. Morrissey as special prosecutor. She has testified before this court, and I submit, and I don't do it lightly, her testimony was false in several material aspects. This court's findings in its order indicate that at the very least, she didn't exercise reasonable diligence to ascertain the nature of those Teskey rounds.
She also made misstatements on her certifications. She certified multiple times in both cases that she had turned over all of the discovery, and we know that that's not true. So I think it is a fair ask because he is a much longer way from getting a dismissal than Baldwin was. But you never know. This is an ongoing pattern. And the court might be like, you know what? No, you don't get another crack at it. You don't get the prosecution doesn't get another go. But it's interesting that he's saying if the court goes to a new trial, which is a more likely remedy, if the court goes to a new trial, then Morrissey has to be out. And that's going to cost the taxpayers of the state of New Mexico quite a lot more money.
Because she was at that March 6th meeting. But I would say at the worst, because Ms. Morrissey's been thorough in other aspects of this case, she did see those rounds. She did know that they were, there was 3 separate primary rounds before July 12th. And so, Your Honor, I'm asking that this court in its inherent power remove her from further prosecution of the Rest case. And we were asking for a dismissal on the same basis as this court dismissed Mr. Baldwin's case.
They're different.
All right, thank you. Response?
Oh, her face is just like,
initially,
now
I
what?
want to just ask, Mr. Bowles indicated that there was an affidavit provided by Ms. Johnson. I don't have that. I haven't seen it attached to any of the pleadings, so I'm not sure
That's a very fair point. I'm going to go look for it too.
what he's referring to. So if obviously he mentioned it, can I get some insight into
It's in the
when that
Baldwin
was provided?
motion. We're waiting for Bowles to unmute. Bowles.
Your Honor, I will try to locate this in the
Bueller.
pleadings, but there was an affidavit filed with
Was found in the
that's in the
Baldwin
court
case.
record in the recent Baldwin response.
That's not your case.
But I think I've
If that's what we're going to do, Carrie's going to be like, right, and we gave the Hague report to Baldwin's attorney, so you can't argue this. Your Honor, it was filed in the Baldwin case, so it counts in this one. No. No, sir.
Attached one in this case as well. I just would have to find it.
Oh, I'm going to go look for it.
Well,
Apologies for the typing.
is it in here? When did you file it?
Judge, I thought I filed it with our motion, our reply
We
to
would have
dismiss.
seen it if you
but
did.
I'm not seeing it right away.
Then you didn't. Oh, there's no exhibits to this motion. There's not.
The
He didn't file
motions
the
I printed
exhibits.
out don't have the exhibits, Your Honor, so I'm not seeing it.
You didn't file the exhibits then. Sorry.
Well, I just went through every motion that's on Odyssey that has the exhibits attached,
This has no exhibits.
and it's not there.
No.
So,
All right. If you can't produce it, I'm going to strike that part of the argument regarding Ms. Johnson.
Yes, Your Honor, and I would just say that part of the court record in the Baldwin.
Y'all are like, Bowles is doing great, sir. Filing your motions without all the exhibits is... Dude! Who said brah in the chat? For all of you that said brah.
bruh.
Damn it, Bowles! Baldwin's lawyers did all the work and like handed it to you on a silver platter, and you're still like, I didn't file the exhibits.
Bruh.
They're not there. And it doesn't note that there are exhibits in the motion. Like the motion doesn't cite to any exhibits, indicating that there would be exhibits that I can see. I don't see any reference to them in footnotes in a quick scroll through. All right, let's see how we go from here. Well, back to the Bowles you all know. Does everybody feel more comfortable now? We feel reoriented. We're like, all right,
Cases that
we're
there
better.
is one filed in the recent
We're better
response. Mr. Nika's filed.
But it's not in this case.
Yes, I can't find it readily, Your Honor.
Okay, so I'll strike that part. Go ahead, Ms. Morrissey.
I
Morrissey,
will say that
Morrissey is calmer than any attorney I know could be. I don't understand how she does it, but Morrissey is calmer than any attorney sitting in court being called a liar in a Your Honor, she lied on the record in a motion, in her not her affidavits, in her testimony, in her Brady declarations under 5501. Your Honor, she has lied to this court over and over and over, and she's like, I don't see that exhibit attached. I can't. I don't understand. If somebody had come to me at work and been like, hey, you said you were going to turn over these exhibits, we're missing these 3, I'd be like, that is so my bad. And then I would absolutely spend weeks being like, you're the worst. How do you forget these things? The ADHD is giving, you're going to get disbarred. Like, get it together. And we're talking at the earliest phases of trial. I would have felt sick to my stomach. I don't understand how she is so unbothered. How are you this confident in the face of everything? I can't even. For all of you that beat yourself up over the minorest errors at work, just remind yourself that you're not Carrie Morrissey. And maybe just be like, we need some, I don't know what this is. The Delulu?
that this is an issue that Mr. Bowles raised in his initial motion for a new trial. I responded to it. I stand by my response. I summarized the conversation that I had with Ms. Johnson, and Ms. Johnson indicated that she wanted the case dismissed out of issues that she was concerned about for self-preservation.
Do not come up onto this internet and besmirch Erlinda Johnson. I try to be neutral. I really do. I am not neutral in this in the fucking slightest. I am an Erlinda Johnson stan, quadrupling down on this, saying she was trying to do this out of self-preservation is just despicable behavior. Just how, you know whose legal team is going to be like, this is our girl? Diddy's legal team. Diddy's legal team is going to be like, You want to practice in New York? We got you. Leave Erlinda alone. I'm going to back up because the audacity is just, we're going to watch it again. We're going to watch the audacity happen in real time again. She's going to do this to herself.
Initial motion for a new trial. I responded to it. I stand by my response. I summarized the conversation that I had with Ms. Johnson, and Ms. Johnson indicated that she wanted the case dismissed out of issues that she was concerned about for self-preservation.
Ew.
I disagreed with that. I don't think self-preservation is a reason that you dismiss a case. There's a legal analysis.
And again, the court struck the defense's argument about what Erlinda said because they didn't attach the affidavits. So the only thing on the record about Erlinda Johnson is what Carrie is saying, and she is leaning into it. Girl.
Analysis that has to be done in order for the court to consider disqualifying a prosecutor. Mr. Bowles hasn't cited to any of those cases, and he hasn't put that legal analysis in any of his motions. So I would ask the court certainly not to consider granting that without a motion that actually addresses the law and the facts as they relate to the law. This isn't something that you just randomly ask for. The legal analysis has to be conducted, and it hasn't been conducted here.
You filed motions with no law at all. What? Ma'am! The self-awareness. We're never going to get through this hearing. This is so wild. Your Honor, he didn't even cite the law. Like, he didn't make a motion to remove me. So, I mean, how could you? I'm dying.
So, having said that,
I did say I was ready for some spicy hearing. I did say that. I did say that. I'm ready for a day in court. It's giving.
I responded.
I'm going to back you up because I was so flabbergasted that I forgot what the fuck you were saying. I glitched.
Analysis in any of his motions. So I would ask the court certainly not to consider granting that without a motion that actually addresses the law and the facts as they relate to the law. This isn't something that you just randomly ask for. The legal analysis has to be conducted, and it hasn't been conducted here. So, having said that,
okay.
I
Sure.
responded to Mr. Bowles' concerns about the veracity of my testimony. Quite frankly, I'm not sure that it's relevant to his motion for a new trial. But because it's something that he's put in his motion and it's something that he has argued, there was no meeting.
I'm going to sit on my hands
about these Teskey rounds. I did not attend a meeting. I did not see the rounds until July 12th. I did not see the doc report until I believe it was July 12th or July 11th. I'd have to check my email. Whenever I got it, and I provided it to the defense attorneys. I had no idea that there were 3 rounds that had the same characteristics as the live rounds from the set of Rust until July 12th. Mr. Bowles can complain all day long that he thinks that's not true. I'm telling you it's true. And how that...
We're going to pause while she's saying, I'm telling you it's true. This would generally work if this was the only issue. If this was the only issue where she's saying, I testified truthfully, I didn't elicit false testimony, I didn't know. But when you pile it all together, the court is not going to just take her word for it. Plus, even if she didn't actually see them, she may not have, she may have. But even if she didn't, the knowledge is imputed to her because the prosecutorial team has it, and CST Popple saw them and presumably Hancock saw them. So it doesn't matter if you did not put your peepers on them, the knowledge is imputed to you. And if you didn't go find them, and if you didn't know, it's still your problem. It's your job to know. And the law says that you know, even if you didn't actually see it. But she's like, I didn't see anything, and I didn't elicit false testimony from my witness because I didn't know. That's not how all of this works. And she's like, I wasn't on a meeting. Hancock said you were. So who's lying? Or is everybody kind of lying? Is everybody shading the truth in their own way for self-preservation?
Ended up happening.
Oh, tell us again what
is
ended up
actually
happening.
Quite clear, because what happened in this
Ma'am.
case is that Mr. Teskey took a photograph of the rounds that he had in his possession,
Again
and he
with
sent
this.
it to Seth Kinney. We ended up with that photograph. I've included that photograph in my response to this, to Mr. Bowles' motion for a new trial. It does not show any ammunition that looks remotely similar to the live rounds that were found on the set of Rust. He went further than that. Mr. Teskey said, I looked at these rounds, I couldn't find any with silver primers. Okay, so at this point in time, the state, this is long before I ever came on the case, but the state understands at that point that the ammunition that he is in possession of does not look remotely similar to the live rounds on the set of Rust. That doesn't make them material. It's okay for us to say, we're not going to collect those because he sent pictures and they're not material. Then we go ahead and we do his pretrial interview. And I decide, maybe I should go ahead and collect those. So I make that statement to him during the pretrial interview. Mr. Bowles can argue all he wants that,
But it just was a statement in passing, and then she's like,
he was assuming that we were going to take him. He had no idea that we weren't going to collect him. I had an email exchange with him in January that's attached to my response where I explained to Mr. Bowles, I am not collecting that ammunition. If you want it collected and you want it tested, go ahead and do it and ask for a continuance of the trial. That is a conversation that took place over
She did
email,
attach
and it
the
is
email.
attached to my response.
she did attach the
So
email.
Mr. Bowles understood we were not going to collect it. And it was during that email exchange that Mr. Bowles then provided more photos of the Teskey ammunition. And those photos matched exactly the photos that were provided to Mr. Kinney by Mr. Teskey, and they showed rounds that were completely dissimilar
Right.
to the live rounds on the set of Rust. This is information that is coming from Mr. Teskey, and
Look
it's
like you're laughing.
filtering through Mr. Bowles. So Mr. Bowles doesn't get to come to the court now and say, hey, they should have collected these. The information that he gave us caused us to reasonably
But you also shouldn't have hidden them.
believe that they were completely
Perhaps.
immaterial. We had no idea that any of those rounds matched the live rounds
Until
from the set of Rust. Mr. Bowles provided us a photograph in January, a month before the trial, for heaven's
Until-
sakes, that showed that they were completely dissimilar. So then let's jump to the trial. This is where Mr. Bowles' argument completely fails. He wants to rely on the court's dismissal of the Baldwin case, but he can't rely on that because what happened was these rounds were in the possession of his witness. He told his witness to bring them to court. He got to look at them. He told his witness, I'm not going to
I'm
call you
shocked
as a
she's
witness,
incredulous.
and I'm not going to take these rounds. We're not going to touch any of this. I understand why he did it. Because, again, as I have said, sure, in a world of infinite possibilities, can you argue that these rounds somehow came on through Seth Kinney? I guess, but you can certainly you have a much stronger argument that this is how they came on through Ms.
That's not the
Gutierrez.
standard.
Her father had these rounds that were exactly like the rounds that she brought on.
You know why she's focusing on the rounds and not the Kinney interview and everything else? Because the rounds argument is not good for Hannah. The other arguments are, but she's banging on about the rounds. The rounds are not the issue for me. The Hague report, the Seth Kinney interview not being turned over, these are bigger problems, but she's sticking to the argument where it feels incredulous. Your Honor, he had access to them. We had access to them. We all saw the same picture. None of these were the same. So why would we even deign to collect them? To be fair to her, trying to collect rounds in a chain of custody interstate from another law enforcement agency is not simple, but all of the other stuff piling up becomes a problem. And the photos that were provided did not show any silver primer rounds. That's true. All of the conversations back and forth with Troy Teske didn't show any silver primer rounds. But then when he showed up at the end of trial, he had silver primer rounds. I think that's also something to be concerned about and questioned, but it's not something that can be hidden. But it opens up Troy Teske to, hey, those aren't the rounds you showed everybody back in January. Hey, those aren't the rounds. That's not what anything looked like. Hey, you told us that there were no rounds with silver primers. So where did these come from? Aren't you friends with the defendant's dad? Like, aren't you besties? So where did these rounds come from? That's a perfectly fine argument, but you have to turn them over. This is different, though, because the defense had access to them too.
So Mr. Bowles knew about this during trial. So when we're doing the legal analysis for
Tell me more
whether
about
or
legal
not
analysis.
Ms. Gutierrez gets a new trial, she does not get a new trial based on this ammunition that was in the possession of her father's good friend and that she and her lawyer had during trial. The state did not have. She and her lawyer had them during trial and chose not to use them. That is exactly what happened. So the legal analysis, the 6 factors that this court has to look at
I do trust
when
her.
deciding to grant a new
I trust her to accurately state the factors.
trial. The second one is that the newly discovered evidence has to be discovered after trial. That's not the case here. This evidence was discovered by Mr. Bowles during her trial when the state had no idea what those rounds were comprised of. He made the judgment call, hopefully after consulting with his client, not to call Mr. Teske and not to use the rounds. They don't get to now come and say, we made a strategic error, so give us a new trial. That's not how this works. So the issue of the Teske rounds with regard to Ms. Gutierrez's motion for a new trial, it is absolutely, it's not permitted under the law. It was not discovered after trial. Here's the other thing that the court needs to take into consideration. A motion for a new trial can be filed for almost any reason within 10 days of the conviction. Mr. Bowles is limited to a motion for a new trial based on newly discovered evidence beyond the 10 days. So Mr. Bowles, having seen those rounds for himself on the second to last day of trial, having infinitely more information about those rounds than I had, easily could have filed a motion for a new trial within the 10 days, but he chose not to do that. So he has given up, he has waived his right to use that in a motion for a new trial. Furthermore, I want to point out to the court, Mr. Bowles filed a lengthy motion for a new trial, and never once did he articulate or argue the legal standard that is required for a new trial.
Ma'am, you filed a motion for reconsideration and also never articulated a standard or law to allow the court for that motion for reconsideration. Really? This is where we want to go? We've read all your motions, Carrie.
Trial. Never one time. And I'm glad that Ms. Gutierrez is listening to this, because the legal standard that he is
trying to throw him under the bus to his client is wild.
Required to meet was never mentioned one time during his motion. The state mentioned it in the state's response because these are the 6 factors that the defendant has to meet in order to get a new trial. So let's move on to the Kinney interview. Mr. Bowles outlined, I think, approximately 20 statements in that interview that he had specific concerns about. And he's absolutely right. I want you to know this was suppressed. The moment that I found out that this audio recording existed at the district attorney's office, I immediately provided this to Mr. Bowles. I couldn't believe that there was an audio recorded interview of this witness that had been sitting at the district attorney's office that had never been uploaded to the discovery server. The previous prosecutors were unaware of it. I was unaware of it. My team was unaware of it. It was absolutely a failure.
Yep, but your office had it.
There's no question about it. I immediately provided it to Mr. Bowles. But that's not the end of the analysis. The analysis is Mr. Bowles has to meet those 6 factors in order to get a new trial. So what Mr. Bowles did was he filed a motion and he outlined 20 statements, the vast majority of which were statements previously made by Mr. Kinney that were already in the possession of Mr. Bowles and Ms. Gutierrez. So then when we get to Mr. Bowles's reply, what we see in the reply is that the 20 statements have now basically been narrowed down to 5, because someone had to come and point out that Mr. Kinney had already talked about the fact that there were 325 rounds that were taken to Texas. He had already made all of those statements about Sarah Zachary being the boss. He'd already made all of these things. So Mr. Bowles filed this motion, having seemingly not reviewed any of the discovery that was in his possession with regard to Mr. Kinney's statements.
So let's not talk about not reviewing discovery, shall we?
So that he could file a motion that actually had the material issues related to the Kinney interview. So now we're down to the 5 issues that Mr. Bowles ends up relying on, because the other 15 turned out to be things that really were already in his possession, were already within his knowledge. So when we go through and we look at these, I'm sorry, there's
something's clicking.
I think he narrowed it down to 8. So where he is right now is he's asking the court to grant a new trial because the interview with Mr. Kinney talked about that there was a standard that Ms. Zachary was the boss and she's managing things, which allows the armorer to focus on guns. This came out during trial. Not only did it come out during trial, it was fully articulated in the text messages between Mr. Kinney, Ms. Zachary, and Ms. Gutierrez. Hannah has more experience on Westerns than Mr. Kinney did until 1883. Well, I would hope so, because Mr. Kinney is not an armorer. So the comparison between Ms. Gutierrez's experience and Mr. Kinney's experience has absolutely nothing to do, is completely immaterial with regard to this case. And importantly, the factors that this court is required to consider do not create a situation where Mr. Bowles gets a new trial because there's something out there that could be potentially impeaching. The law actually doesn't give him that with regard to a new trial. His third issue, prop masters who handle guns won't call out armorers to test bullets. I don't understand. I mean, I don't understand how that could even be remotely material. We had plenty of evidence from people who were on the set, who work on movie sets. Mr. Kinney does not, by the way. He doesn't work on movie sets. And we had an expert come in and say,
he's a prop house that's plot. So he doesn't physically go onto the set, because he sure was at the set of 1883. But
the armors are supposed to test the bullets.
Okay.
So how is this material? The sheriffs confused the replica guns with the real guns. What does that have to do with the elements of the offenses that Ms. Gutierrez was charged with? It has absolutely nothing to do with those. Mr. Kinney heard nothing but good things about Hannah on set, and all of the concerns about safety that came out later he hadn't heard about. Judge, that's all in the text messages that Mr. Bowles had. He had all of that. Mr. Kinney actually, there's an exchange between Mr. Kinney and Ms. Gutierrez where she talks about the director saying what a good job she was doing, and Mr. Kinney responds. All of that is in the text messages. This was always in Mr. Bowles's possession. Mr. Bowles didn't review it. He didn't use it during the trial. That was his decision. Sabotage could be anyone on set.
Old.
Mr. Kinney doesn't work on movie sets, and he was never on the set of Rust. Okay, so this is his speculative opinion. It was also something that Mr. Bowles had the opportunity to fully explore at trial, and did in fact fully explore at trial. Because Ms. Gutierrez left the ammunition unattended, anyone could have messed with it. Yes, we went through all of that. Because these firearms were left unattended, yes, anyone could have messed with them. We knew all of that. All of that came out during trial. The idea that if the camera crew had gotten their hotels, would they have still felt unsafe? This is number 7 in Mr. Bowles's reply. This has absolutely no material value with regard to the case against Ms. Gutierrez in any way, shape, or form.
To tone her down just a little bit.
That the assistant director and Alec Baldwin didn't give Hannah every ounce of support, and she got pushed around. Well, this was Mr. Kinney's opinion, but you also have to keep in mind, Mr. Kinney was never on the set of Rust. Mr. Kinney never met Mr. Halls, the assistant director. He also never met Alec Baldwin. So this is a statement that he made that has absolutely no foundation, and also is completely immaterial to the case against Ms. Gutierrez. Now, we get into the issue of the third Hague report. And
are you going to again say this is absolutely suppressed?
That to a certain degree, the job of a defense attorney is to make things seem perhaps a little worse than they are because it helps their arguments. Nothing was intentionally buried. This case had a terabyte of discovery. There was new discovery coming in constantly. This was a report that I believed I had forwarded on to our staff to have it uploaded to the server.
You didn't.
When I realized during the Baldwin preparation for trial that did not occur, I immediately I took full responsibility for it. Mr. Bowles points to the email where I took full responsibility.
I took responsibility. Ma'am, that's not the standard. I took full responsibility. It doesn't matter though. Okay.
Responsibility for it as though I've done something wrong by taking responsibility for it. I believe that it had been forwarded on. I went back. I looked. It had not been
what you were supposed to do.
We did the best that we could to resolve it at that point in time. And listen, the problem with Mr. Bowles's argument with regard to the Hague report is twofold. First of all, the Hague report clearly says the microscopic marks on the tip of the sear did not affect the functionality of the gun.
But it was still a
Furthermore,
report.
Mr. Haig has since learned exactly how the destructive testing of the gun was being done and has now come to the opinion that these microscopic marks were made by the testing at the FBI. So Mr. Bowles wants to say, Judge, it doesn't matter. The fact that the guy has changed his opinion after he got new evidence, that stuff shouldn't matter. Well, it most certainly does matter, because when you look at the 6 factors that this court has to consider when granting a new trial, is the probability that the result would be different if the new trial was granted. So if you have an expert who
She should maybe
said,
focus on that.
initially, I'm not exactly sure where these microscopic marks came from, but I don't think that they came from the FBI. Then he goes and he talks to the guy at the FBI, gets more information about how that testing was done, and the expert then says, okay, now that I've got this new information, I've changed my opinion. I think that they did come from the FBI. Well, that goes directly to the first prong of the 6
Okay, I'm going to
prongs,
stop with the FBI.
which is
maybe.
whether or not a new trial would result in an acquittal if the court were to grant the motion. It's not going to, because Mr. Haig got more information about the testing, modified his opinion, and the other thing is that Mr. Bowles hired, although I don't think he paid him, but he had his own firearms expert. Not only did he have his own firearms expert, he used an investigator in this case who purports to have a fair amount of expertise in firearms. So you've got basically 2 people who have expertise in firearms working for the defense, and you have the photos of the sear and the microscopic markings on the sear that were provided to the defense for their review. Not only did they have the photos, but the gun was sitting over in evidence. They can go, they can look at the gun, they can take the gun, they can test the gun. They can do any of those things, and they opted not to do any of them. Now, presumably, either the defense expert, Mr. Kuski, or the defense investigator was tasked with going through all of the photographs that Mr. Haig took. What Mr. Bowles has actually said in his reply is, oh my gosh, Judge, there were so many photographs. We can't be responsible for having to review all of those. They certainly can be. They needed to review each and every photograph. I know how long that takes because I did it myself. So the basis of the Haig opinion was always in the possession of the defense. And they seem to just basically ignore the fact that they had the photos, that they had their own expert, and they basically had their own expert come in and say, we agree with Mr. Haig, the gun worked fine. That was the reason that they called that expert, was just simply to say, we agree, the gun worked fine. They had everything that they needed. But listen, I'm not trying to take away from the fact that this was a report that should have been provided and wasn't provided. I have taken full responsibility for it. I will continue to take full responsibility for it. So I want the court to know I'm not trying to get around that. But one of the factors that this court has to consider is, would the newly discovered evidence have been discovered before trial by the exercise of due diligence? They had a photograph of it. They had a photograph of the markings on the sear, and not only was it a photograph, right next to it is a photograph of a sear without those markings. It was in the possession of the defense the entire time. So
that is a fair argument.
Easily could have been discovered by due diligence. That due diligence meaning simply go through the discovery that you have. Go through the discovery that you have. And you know, New Mexico is unlike so many other states, in fact, perhaps all states, because defense attorneys actually get to interview the state's witnesses. So that is the opportunity for the defense to exercise their due diligence to discover things. That's the whole point to the pretrial interviews. So in this case, what happened was we had a pretrial interview scheduled of Mr. Haig. Mr. Bowles did not attend. Because Mr. Bowles did not attend, I think 95% of the pretrial interviews. So he opted not to attend. He left it to his investigator. His investigator conducted a 25-minute pretrial interview, and not a single question was asked by the defense investigator about any of the photographs that the Haigs took. They asked about the damage to the gun. Mr. Haig indicated there was damage to the gun. He further indicated that the sear was damaged. That came out in the pretrial interview. So when you look at the 6 factors that the court has to consider when granting a new trial, the defense doesn't get there. They simply do not get there. I further have some concerns for the record. So one of the issues
I'm dying to hear
that Mr. Bowles has made an issue in these motions, which is a little confusing to me, is the issue with regard to the standard of state v. Ware. So what he's arguing is that
I mean, the state should be Ware in this case, but
in
that was
Teskey's
just too easy. I
possession,
couldn't leave it go.
under Ware, the state had the obligation to go and collect, and by not collecting it, that resulted in a due process violation to his client. Here's the problem with that argument. I sat and went through every single New Mexico case related to Ware. I can give you the list, and for the record, because we have so many potential appellate issues, I'm going to tell you, Judge, not only did I look at State v. Ware, I looked at State v. Crone, which was provided by Mr. Bowles. I looked at State v. Kinney, State v. Torres, State v. Martinez, State v. Camden, State v. Rodriguez, State v. Bailon Escobedo, State v. Baca, State v. Garcia, State v. Kant, State v. Taylor, State v. Perkins.
Ma'am, this isn't helping your case.
Those are the New Mexico cases
Great.
that discuss the Ware standard. Every single one of these cases says that the obligation of the state has to do with collecting evidence from the crime scene. And they make it very, very specific. And Ware indicates this is very limited. The state is not required to scour the planet Earth for potentially exculpatory evidence. It is evidence that is from the crime scene. This is not evidence that was from the crime scene. This is evidence that was in the possession of a defense witness. Mr. Bowles knew in January that we weren't going to collect it. He knew that it had never been collected. He certainly did know that because he was in contact with Mr. Teskey. Mr. Bowles could have had that ammunition tested. I mean, the chain of custody was shot. There was never going to be any chain of custody with this anyway. This isn't something that was located at a crime scene and was taken into evidence. This is something that was sitting in a defense.
There still is a chain of custody. Anything that gets collected, wherever it gets collected from, is still a chain of custody. What in the world is... What is it? What are we... Words are just happening that have no meaning.
Witness's garage. So Mr. Bowles could have had this tested. He opted not to have it tested. He could have had it tested. He could have had those test results compared with the test results of the FBI. And the best case scenario for the defendant is that would indicate that the same powder that was used in the ammunition that was in Teskey's possession is the same powder from the powder, or consistent rather, with the powder from the ammunition from the set of Rust. And that exact same powder is used in millions and millions of rounds of ammunition everywhere. One of my concerns since this issue arose has been the fact that Mr. Teske 2 times sent photos of the ammunition in his possession, twice, and never sent a photograph of a round with a silver primer. In addition to that, he indicated, I have looked at these rounds and there are none with silver primers. And then 2.5 years later, he shows up with ammunition
That's a
that looks
concern for
just
me
like
too.
the ammunition from the set of Rust.
That's a concern for me too.
And again, you can buy this ammunition at any gun store.
But that's
this
not the
isn't
biggest
special.
problem.
You can get it anywhere. You can get ammunition with these exact same characteristics at any gun store. So out of, to be thorough and complete, the where analysis doesn't match in this case. It absolutely is really irrelevant to this case, because the defense had more access to this ammunition than the state did prior to Ms. Gutierrez's trial. Now, with regard to the Baldwin case, that's a completely separate issue, because that is information that was in the state's possession prior to his trial. So there are real issues with regard to that disclosure. That's completely different. This case, Mr. Bowles had it in his hand. He had it in his hand during trial. And Mr. Teske, I'm not making things up, Mr. Teske told law enforcement on...
Is that really what you want to say? We heard what you had to say about her, Linda.
Video, I offered this to Mr. Bowles and he said he didn't want it. That's what Teske says on the video. So, Mr. Bowles acts like I'm pulling this out of thin air. I'm not. That's what Teske said. He said Bowles didn't want it. And again, Judge, I understand why he didn't. So I also want to articulate, because I think that this is an issue that Mr. Bowles is raising and is arguing, specifically with regard to the reply that he filed. And let me be specific in his reply, if you'll give me just one moment.
I mean, is it going to make it better? Probably not. Are we doing it anyway?
I'm just reviewing my
Seems like we are.
Notes here real quick. So with regard to Mr. Bowles's reply, he says, both parties, the defense and the state, knew that Teske had ammunition from the same batch that Reed and Kenny took to Texas. I disagree with this statement insofar as it oversimplifies what happened. So both parties knew that Thel Reed possessed a
Now we know why she needed 52 pages for a 10-page motion. She's just going to tell you 52 pages for a 10-page motion.
Variety of .45 caliber ammunition with a whole lot of different characteristics. That was that was proven by the photographs. It was proven by the ammunition that was taken from PDQ into the sheriff's department. So, but what there's no proof of, absolutely no proof at all, is that each type of ammunition that was in Mr. Reed's possession went to Texas and then went to New Mexico. So if Mr. Reed has 20 different types of .45 caliber ammunition, and it strikes me that he had about 20 different types of .45 caliber ammunition, there's absolutely no evidence or testimony that the ammunition that is silver primer starline brass with that particular projectile shape ever went to Texas, let alone ever came to New Mexico. So when we say it came from the same batch, I guess my concern is, what do we mean by batch? If there is evidence, actual evidence, that these specific rounds went from Arizona to Texas to New Mexico, I've never heard it.
Okay. And?
Mr. Bowles actually went so far in his reply to say that the Teskey evidence was deliberately hidden from him. The Teskey evidence wasn't deliberately hidden from Mr. Bowles. It was provided to him by his own witness. He could have had it tested at any point in time. I would respectfully ask the court to deny Mr. Bowles' motion, and if Mr. Bowles wants to file a motion to disqualify me, he can file that motion. That is a separate motion. There is case law on that motion.
To
I would ask
disqualify,
the court to deny this motion. Thank you.
Oh my gosh, she's done.
Thank you, Ms. Morrissey. Reply, Mr. Bowles.
Yes, Your Honor. Thank you. Your Honor, I want to start off by telling the court
What the fuck?
Several initial points. The Teskey evidence that was deliberately withheld was the Teskey supplemental report. We still have Brady rights on appeal. That was not given to us, the March 6th report. So Ms. Morrissey misconstrued that. She also misconstrued the idea that I didn't want the evidence. What I told Mr. Teskey was that I didn't want to be in the chain of custody of those rounds. And I was actually a good idea that I did not, because Ms. Morrissey's now accusing Mr. Teskey, in essence, of planning silver primer rounds in that group of rounds. She just made that argument. Now, Mr. Teskey originally, way back when this case started, did a cursory search through the rounds and did not locate any silver primer rounds. He thereafter didn't touch them, and that's where the text came from very early on. He didn't touch them. Miss Morrissey was saying she's going to come get them. That's what she said at the interview. So by the time we have the email exchange, which, by the way, Your Honor, she didn't email me. I emailed Miss Morrissey trying to figure out where this was at. And then she responded, I'm not going to get these rounds. It was too late. This court had made clear, and I don't remember the exact date, but that we weren't going to continue the trial. There was not sufficient time at that point to test them. And we could not test them, Your Honor, because the FBI had the powder for the live rounds on set. We don't have an ability to match those unless they're tested at the FBI. So the state did suppress those. And we're not asking on the where standard for them to go to the ends of the earth, as Ms. Morrissey said. They knew the individual who had them. They knew this early on. And that, as the court put in paragraph 30 of the court's opinion from July 31st, there was a progressive trail established of how these rounds could have gotten to the rust set through Mr. Kinney. Now, Ms. Morrissey wants to denigrate that idea, but finally today she said, well, I guess in a wild speculation, you could say Mr. Kinney brought them. No, that's a real possibility. That's something the jury should have been able to consider, but they never wanted to acknowledge any possible defense theory, which is why they suppressed everything, because Ms. Morrissey didn't think it was relevant. With regard to the Hague report, Ms. Morrissey made extensive argument about how we should have divined these microscopic or very small damage to the trigger and sear through looking through thousands of pictures.
This is not your strongest argument.
And having our experts somehow divine the opinion of Mr. Hague
that's fair.
Or come to the same opinion as Mr. Hague. But what she's ignoring and trying to get this court to ignore is the failure to produce that report from the main state witness who was opining on whether the gun functioned correctly. And I just accepted that at trial because I accepted his answer that there was no modification that affected, and no modification other than the FBI testing, which that was the case in the pretrial interviews. That was the case at trial. Ms. Morrissey said pretrial interviews are where we can figure these things out. Well, we couldn't even figure out at trial because he didn't answer the question in a truthful manner. What he said was there is no other modification to that trigger or sear. Now that's false. And Ms. Morrissey wants to conveniently skip over that and the idea that we should have had this and it's no harm, no foul, even though we have
fair. It's not no harm, no
proof
foul
of false testimony. And she's admitted we didn't get the report. That's something we could have absolutely crossed on. and used under 14-251 on this idea that the court pointed out in Mr. Baldwin's order on the negligence of third parties and the proximate cause argument. Your Honor, regarding the Seth Kinney statements, I did read it all. I boiled it down in the reply to the 8 most important, and that's why I wanted to get to the court to consider. Ms. Morrissey tries to, again, run away from the idea that she suppressed something by characterizing it as we had it all. Well, we didn't have it all, and we didn't have it specifically all from Seth Kinney's mouth. So that's not true, the arguments that were just made. And we could have crossed him on that. And he was an important state witness, as this court knows. Your Honor, with regard to the Teskey rounds, what Ms. Morrissey didn't address at all is not the new trial grounds, but we've asked for a dismissal under the court's inherent power. And the whole Teskey argument, and I've been open about it, I didn't see those till 2 days before the end of the trial. At that time, there was no way to do anything with them because they had been suppressed in essence by the state.
I mean, it's a fair argument.
Mr. Teskey not wanting to touch them for the exact reason that Ms. Morrissey accused him today of planning rounds. That's the reason why he didn't do anything with them. But Your Honor, the Teskey evidence and the court's opinion in Baldwin goes to the remedy of dismissal because the egregious nature of this prosecutorial misconduct in this case, specifically by Ms. Morrissey, her false testimony does a blow to the whole system of justice. It's not just to this case. As this court appropriately found and was warranted in Mr. Baldwin's trial, this affects the whole system. Why people respect the system, they voluntarily turn themselves into jail when a judge rules, is because they have respect and confidence and public trust. What Ms. Morrissey did in this case is she destroyed public trust across the board in the Rust prosecutions on a case that was watched by the nation and the world.
That's true.
A case being paid by the taxpayers, one of the biggest debacles, ethical misconduct, probably in the history of New Mexico. But this court appropriately dismissed that case
debacle in the history of New Mexico
and maintain and uphold the integrity of our system. And so I'm asking the court to consider doing that in this case as well, because it's not fair and it's not right when the prosecutor doesn't play by the rules.
That's true.
And it doesn't engage in fair play. That undermines our entire system.
That's true. That's true. I don't quibble with Bowles on that. He's very pleased. But also, Carrie's argument got so far afield and grating that Bowles is coming in, even though he didn't attach all of his affidavits, Bowles is coming in as the reasonable one. Your Honor, this fuckery cannot stand. And he's not wrong. It was, I'm very curious to see what the judge is going to do. He's not wrong. And he was like, I did it.
All right. Thank you for your
I did a thing.
presentations today on this particular motion. I will consider these arguments as well as the pleadings.
No.
I will issue
No! Your Honor, today. Your Honor, today. She's taking this under submission.
order. I plan to issue the order early next week. All right. But at least next week.
Early next week.
All right. Let's move on to the
Release motion
for immediate release.
Yes, Your Honor. And that really,
I was overly optimistic. She's going to take it under submission. The reason, and she's taken everything under submission except for the Baldwin motion because they were in trial. I appreciate that she's taking it under submission, but also it's Thursday. We'll probably have a ruling Tuesday, Wednesday. She probably already has most of what she wants to do done and wants to put it all in writing. The way I'm going to be checking for this. I don't want to wait either, chat. All right, let's see the argument for release. That's probably going to get denied today.
think is predicated upon the court's ruling.
So we're moving on to
whichever way the court would rule on the instant motion we just argued. So I'm open to suggestions of this court or counsel. Judge, I don't know if it's ripe until this court rules.
It's not ripe. So that's what he said. The motion for immediate release is not ripe until the court rules. If she gets a new trial, he wants to argue that she should not be held in custody until that new trial. If the court dismisses the case, they let her out. If the court doesn't dismiss the case and doesn't issue a new trial, then she finishes serving her time. So it isn't quite ripe. I wonder if And the reason I paused, I wonder if the court's going to signal what she might do by saying, no, I'd like you to argue it now. If the court's considering dismissal,
I think it's ripe. You've got section 3111(1)C.
if the court's considering, like, I could see a scenario where I might do these things. Let's argue it now. And the court's like, it's ripe. Let's argue it now. Interesting.
And you've also got the case law.
Oh, the way I'm going to be refreshing.
Yes, Your Honor, and with that,
Your Honor, if I could, this was such a convenient time for your ruling. Your Honor, I would just suggest that Wednesday is really good for my schedule. Thursday is really good for my schedule. Tuesday, there's a lot going on here, not so much. I got a concert this weekend. Like, if we're keeping Emily's schedule in mind, the fall is insane. There's weather. Things are happening today. So, I mean, Wednesday's good for me, Your Honor. Wednesday, Thursday. We got a stream on Thursday. We could swing a stream on Wednesday if we had to. But Tuesday's going to be tough. All right, let's hear him argue it. Tori with a T, I'm holding on to your chat to celebrate with you. I'm very excited for you. So we'll chat
am
during
asking for immediate
questions.
release, and some of the same arguments we've already presented with regard to the Hague third report. Judge, this is on appeal. It's been remanded on a limited basis for this court to rule on the motion for new trial. I know that the state has responded that there are issues that Ms. Gutierrez Reed has had with regard to statements she's made. But Your Honor, the fact of the matter is, while she was on pretrial release in this case, she didn't have any violations. She didn't go anywhere. She's not intending to flee. She's not intending to try to avoid prosecution.
She was like drinking and smoking weed and stuff, though. Those are not specifically adhering to the terms of release, but
Your Honor, and I would submit that if or to avoid her obligations to this court, I would submit that she's not a danger. If this court were to enact conditions, she doesn't have firearms. She could be on house arrest or whatever conditions this court deems appropriate. While this case is pending, whatever decision this court makes early next week, but she'd be allowed to be released pending the appeal. One of the problems, Your Honor, is that the length of time of this appeal
is beyond how long she'll be in.
If this case proceeds to appeal,
right,
is likely to take longer than her sentence. And that's just a fact of how the system proceeds. And so,
y'all, I'm going to hold on to the gun in the bar charge. I need to look at the timing of that. I don't think that happened while she was in New Mexico, but not after this case was brought. It happened before October 21st, the incident itself. And so that predated this case. And then she's pleading to that early October. So that's when the plea hearing is set. So that predated this. So it's not a violation of this because she hadn't been charged with this yet. Hopefully that helps. Let's keep going. I saw a lot of you ask the question, which is what I love about streaming. When I see that question like a whole bunch of times, then we know. But the jail calls also are kind of what prove that she was maybe not adhering to all the conditions of release. And we can have other conversations about the propriety of whether you should be allowed to drink alcohol when released on probation or released from custody while you're still, presumed innocent before trial and it's not an alcohol-related charge. We can have conversations about that. But again, for another day. But she was ordered not to do those things and was doing them. And then her jail calls. But she showed up to court when she was supposed to show up to court. She did those things. And I find, depending on how strong the appeal is, I understand a defendant saying, why should I serve 18 months waiting for my appeal if I might get a new trial, if it might get overturned when I am not a danger to the community and my sentence is so short that my sentence may be done? And then what's the remedy? If her case gets overturned down the road and she's already served 18 months, what's the remedy to her? So I understand the argument.
We're asking with the issues we've raised for this court to consider releasing her while this court considers this motion and the appeals court considers our arguments.
Ms. Morrissey.
Your
Morrissey
Honor, the
doesn't think
state
this is right.
objects to the release of Ms. Gutierrez. Mr. Bowles indicated that she didn't have any violations of her conditions of release. I think we didn't have any evidence of those violations that we could bring to the court, but we did discover when listening to Ms. Gutierrez's jail calls that she
Right.
was in possession of alcohol during the trial.
That's not me. That's their Zoom. Drinking during the trial.
Discussed violating the court's order that she not possess firearms during her
Subtitles
jail
going wild.
calls. And she has already signed a guilty plea to a felony in her other case. So Mr. Bowles' argument.
When she discussed violating, it was specifically with regard to weapons. She was like, hey, wink, wink, nod, nod. You could say you got rid of all of them and still let me have access to them. My suggestion to Hannah would be put the guns down and maybe take up barebow recurve archery. Good for the mind-body alignment. You still can go shoot at stuff. Probably wouldn't violate your probation. So I'm just saying there are other things.
That she doesn't have any other criminal history.
I think Carrie's very
I know
happy
that
the judge isn't
argued that
ruling
initially
today.
in his motion, and she has now since signed a guilty plea in that case. So I'm not trying to beat him up over that. When he made that assertion in his initial motion, it was accurate in terms of her convictions. It is no longer accurate. And based on those issues, we would ask the court to deny Mr. Bowles' request to release Ms. Gutierrez. And I will say that one of the things that has mystified me in terms of the way that Mr. Bowles is handling his appeal, he's filed more than one motion before Your Honor asking that the court release Ms. Gutierrez. I think this is the third such motion that I have responded to. I think the court has only heard two of them because one of them was never set for a hearing. But if Mr. Bowles has concerns about the fact that his appeal is going to take so long that essentially Ms. Gutierrez will have served her entire sentence by the time his appeal is over, I don't understand why he isn't addressing that with the Court of Appeals. I think that he can do that. I think that he
but he can also address it here.
Should do that, and he should have already done it. So
he can also
we would
address it
ask
here.
this court, based on everything that we've gone through this morning with regard to Ms. Gutierrez's motion for a new trial, the 6 factors that have to be met in order for that to be granted. I have never seen a case in the state of New Mexico where the district court dismissed a case post-conviction.
I've got a question.
Based on discovery issues.
Have you ever seen a judge dismiss a case with prejudice and then undo it? Because I'm mystified how that's going to happen. But yes, normally the remedy is a new trial. That's normally the remedy. The judge might be mad enough to roll it.
And I don't think that Mr. Bowles has pointed to such a case. So I don't know that asking the court to dismiss the case against Ms. Gutierrez based on the 2 issues that Mr. Bowles was unaware of during the trial is appropriate. The appropriate remedy is motion for new trial. He can't meet those 6 factors. So I remain confused as to if Mr. Bowles has concerns about the length of time of the appeal and how it relates to his client's sentence. File a motion asking for release before the Court of Appeals, because they have a better idea of how long their appeal is going to take than we do.
Sometimes you file it
for
in
some
the
reason he's
court
not done that.
too.
So we would oppose Ms. Gutierrez's release. It sounds like the court's going to rule early next week. So certainly if the court rules
They should go together.
that Ms. Gutierrez gets a new trial, the court can immediately release her. I'm not sure the court even needs to have a hearing on that. I think that's well within the court's power. But the state objects to it, for the record. Thank you.
It's so interesting because there were times in practice when I was like, the people object for the record, which is really like, Your Honor, I'm objecting. You're going to do what you're going to do. I'm not going to really, this is not the hill I'm choosing to die on. Earlier on, Carrie was like, this is the hill somebody's dying on. It might as well be me, but we're doing it. But this one, she's like, if you give a new trial and you release her, I understand that that's probably what you're going to do, because that's the appropriate thing to do. You don't hold someone in prison when you've granted them a new trial, when they were out of prison before the trial, unless a circumstance has changed. So it's kind of an acquiescence, but I just wonder if Carrie thinks that a new trial is likely. And if Hannah Gutierrez gets a new trial, they will make a motion to remove the prosecutor. Would another prosecutor come in here and allow Hannah to plea to the misdemeanor deal that Dave Hall's got? Could we see not a retrial? But she's just like, sure. I mean, it's within the court's discretion. Carrie, can you tell us how it's within the court's discretion to like undo a dismissal with prejudice? Because I still would really love to know. So I wonder if the acquiescence is the writing on the wall.
Your Honor, just briefly. Yes, Your Honor. Thank you. Just briefly. Your Honor, the reason why we are asking for dismissal in this case is that it is the most egregious case I have ever seen of prosecutorial misconduct. And there's always an instance where you have to ask a court for something you're compelled to do on behalf of your client, because there is no case I've ever seen that is this bad. Mr. Baldwin's lawyers wrote that in their response that they recently filed. And this court appropriately dismissed that case. That's why we have asked for the dismissal remedy. Because this case is so egregious, what happened? Lying, cheating, hiding evidence. Second, Your Honor, with regard to the release, we wanted to go through the chain of command. We wanted to address that with this court first.
I think that's fair.
And then we will, depending on this court's ruling, we would go to the Court of Appeals next. But I wanted to respect the chain of command and respect this court's authority of the proceedings, and that this court had previously ruled on those issues. So that's why we filed it. So, Your Honor, we would respectfully agree with Ms. Morrissey, if this court rules in our favor early next week, this court wouldn't have to have a hearing and could just release her.
All right, thank you, counsel. Again, I appreciate your presentations today, and I do appreciate your briefing. I'm going to consider your motions. I will address them in two separate orders. Your motion for release, immediate release under 5402, and then the order on discovery violations and inherent power, new trial and dismissal. All right. Thank you.
Thank you.
We are in recess.
All right. We're done with court in... Oh, wait, there's Hannah. Wait, there we go. Hold on. Now everybody's logging off of their Zoom calls. It looks like Hannah's in a dorm room. I wonder where she's being housed, because that is much more of a difference in custody situation where you have plants and like a real dresser and stuff. So there's Hannah, who was on Zoom the whole time. We just didn't generally see her before this. She definitely looks like she's doing okay. So I hope that even though she is in custody, she is doing well. This has got to be very frustrating for Hannah. I think that, yes, this is where she's being housed. I imagine she is in a lower security prison, but it could also be an office. That's true. Some of you said it might be an office. It could also be an office for Zoom, but she looks like she's doing okay. I was surprised to see her as they were logging off of Zoom. Well, we're going to see who else logs off of Zoom, because why not? As court goes. Look, we normally roll through the end of court anyway, so it's definitely different than the lockup facility. So there we go. As everybody logs off of Zoom, and that's the end of that meeting. But I have empathy for Hannah. Hannah's level of fucking up in this is not to be understated. She had the job of armorer. It was her task to take. She didn't seem to take it maybe with the solemnity that it deserved. And because she didn't check those rounds, a live round ended up in a gun. That can't be understated. But we're going to talk about the other side of this too. Dave Halls, who was the safety coordinator, who was doing none of the things to be the safety coordinator on set, got a misdemeanor with literally no conditions. It was like take a gun safety class and testify truthfully. Baldwin's case uncovered a significant amount of prosecutorial fuckery. So regardless of what Hannah did, the prosecutorial fuckery sits very badly with me. It also sits badly with me that everyone else in this scenario is out of custody and Hannah's not, given everything. In this case, it's not equitable that others that are responsible here have gotten a huge benefit, including Dave Halls. Could Hannah have taken a plea deal? It seems that she could have. Did she want to tell anyone where the ammo came from? It seemed that she didn't. So that looked like a critical part of her plea deal. She has the right to go to trial, but with going to trial, there's consequences. And the consequences in this case, especially with how callous her jail calls were, was the judge is like, I'm throwing the hammer down. This can't happen. However, having a case with so many things kept from the defense, no matter what Hannah did, does not sit well with me. The prosecution has to play by all of the rules, including the Brady rules. It's already a weighted deck when the, government turns its attention to you. They have the resources that you don't. They have the ability to get to all your shit that you can't always easily defend against. And that needs to be treated seriously and not used lightly. And so the amount of bullshit here frustrates me because it is completely inequitable that you have Hannah sitting in custody. Seth Kinney never gets prosecuted, barely gets searched. Dave Halls is like, I completely didn't do my job, and I'm kind of the senior safety person on the set, and I'm going to just take a deal and I'll testify truthfully, I promise. And then Baldwin gets to trial and he's like, I had no reason to believe there was live ammo in the gun, but he was not acting safely with the guns. All of the evidence shows that Baldwin was acting like a complete douche with regard to the weapons and just shooting them around and just having appallingly unsafe behavior. But he also had no reason to believe there was anything other than blanks in a gun, but blanks can do harm. His behavior wasn't great at all, but the prosecution still hid evidence. And it's this very hard, how do you hold someone responsible when the deck is being stacked against them with inequitable behavior from the government? And there has to be a balance to that. And the court is going to be trying to balance that. And it's a hard balance. There should be consequences and they should be stringent when the prosecution does not behave appropriately. Withholding evidence is a huge problem. And I think that the difficulty in it is the remedy for that is generally that you don't get to go ahead and prosecute the defendant, which does not feel equitable to victims of crime. And so it's this difficult push-pull because it's completely inequitable, unjust, and not correct. I've lost words because I'm so frustrated by the amount of Brady violations in this case. It's also inequitable to allow for prosecutorial fuckery to then put somebody in prison for any amount of time. So this case is a difficult push-pull for me because Hannah's behavior is Hannah's behavior. I don't know if any of the things that the defense brought up would change the result here, but I also think a defendant should be allowed to try. They should have everything in front of them. All of that should be turned over. But also, Hannah's words were the strongest testimony against Hannah. I don't think anything else changes the result in this case because any prosecutor comes in, gives an opening statement, and pushes play. Her job was to check the bullets. Her words were she should have checked more. Yeah, she should have. Push play. So I'm a bit torn on this one because the fuckery is so bad, and I want to see stronger sanctions against the prosecutor personally, and I think there's room for the court to navigate that. And the court did that in the Baldwin ruling. The court threw down some of the heaviest language I've seen a court levy against an attorney ever. And that is not to be understated. I'm interested to see what the court does here. I don't think it changes the result. So we'll see what the court does. And that's where the push-pull is. There needs to be a discovery sanction against the prosecution in Hannah's case as well because of the after-discovered reports. I don't know if the appropriate sanction is a new trial. I don't know if the appropriate sanction is just monetary sanctions because I don't know if it changes the result. But we'll see what the court does. Could the court dismiss it? It's the rarer circumstance. Could the court grant a new trial? They could. With all of that, I'm going to try to summarize what happened in this hearing today, and then we are going to, that was just my thoughts. Emily, was that your soapbox? That was just me ranting about the push-pull. There's not a clean answer to it. I wanted to acknowledge the push and pull of this case and where it's hard, because there's a lot of things in law that are, that there are a push-pull to. And I don't know what the judge is going to do, and I don't know what I want the judge to do here. So I was still surprised, and I'm still surprised that the judge sentenced her to 18 months. I was still surprised. So let's try to do a summary of the hearings today, and then we'll go into some Q&A. I'm going to take a lunch break, and I'm going to populate a new stream for the Kohberger hearing this afternoon. I also have a lot going on that I need to go check into. Members, there is so much going on. We will do an entire, our next members only live is going to be like 4 hours long. We are going to have a whole conversation about the adventures of today. But we're not going to do that on stream. Right now, I'm going to take a breath, and we're going to do a quick summary, and then we're going to start a new stream. The Kohberger hearing, I think, what time? Miguelino, will you remind me? I'm sure the chat knows. We will put it up. I think it's 3 p.m. Central. Thank you, Miguelina. So we will put a stream up for 3 p.m. Central. Again, I'll start a little bit delayed on that, but it'll probably be closer to on time than now. And that'll give us about a 2-hour break, get some lunch, hydrate, do the things, batten down the hatches, stay dry, don't let the wind get you, all that stuff. But we're going to do a quick Q&A after we do a quick summary. Well, Carrie Morrissey and Bowles were back in court today in front of Judge Summer to argue the motion to dismiss with regard to Hannah Gutierrez's case. Bowles was arguing prosecutorial misconduct in sum, arguing that there was a full recorded Seth Kinney interview that never got turned over to the defense until after trial. There was that expert Haig report that didn't get turned over until after Hannah's trial. And then there were the Troy Teske rounds. At the beginning of the hearing, Bowles tried to restrain himself from saying that Carrie Morrissey had been lying. By the end, he did say that the prosecution lied and cheated. But at the beginning, it was that there was shading of the truth, that Carrie Morrissey testified in the Baldwin case and that she lied about what Erlinda Johnson said. She lied about the meeting that was had, about the Haig, about the Teske rounds and more. This is the first time we got to see Carrie Morrissey actually speak to everything that went on. And Carrie Morrissey was just like, okay, so I don't know if any of my testimony in the Baldwin case is even relevant here. And then she spoke for 152 pages about the Teske rounds and how the defense had them. And so that's not on her. And that, everything that Haig said in his other discovery was also in this one report, so they were aware of it, and that she was also appalled by the fact that the Seth Kinney interview wasn't turned over, and the prior DAs didn't turn it over either, and she didn't even know it was there, and she had no way to say that that was not uploaded to the portal, and there was like a terabyte of discovery. There's no discovery exception that I know of that says, well, if it's a lot, we'll give you some grace on turning over reports to the defense. No, it's not like, okay, well, over 50 gigabytes, we're going to like do our best. That's not how any of that works. So Carrie admitted that they didn't turn over evidence to the defense, but still argued that even though there is this new evidence discovered after trial, that still doesn't change the outcome of the trial. And that when you go through the legal analysis, which she said Bowles did not do, she's like, Your Honor, he didn't even cite the standard in his motion. Remind me again what the standard is for a court to reconsider a motion to reconsider a dismissal with prejudice. What's the standard there is my question. But she said that Bowles didn't even cite the standard, and under the standard, none of this after discovered evidence would have changed the outcome of the trial. Bowles is asking for a dismissal for egregious prosecutorial misconduct. Then he is asking for a new trial, and if a new trial is granted, to release Hannah Gutierrez from custody pending that new trial, or to release her from custody pending appeal. And he's asking that the prosecutor be removed. And Carrie said he didn't even like file a motion. You can't just come in here and ask for stuff. It's a summary, but it's a pretty accurate summary that's what she said. So it was a extended hearing, probably more so because I kept pausing because some of Carrie's arguments were just, and I was shocked. But she has quadrupled down on the, none of this is relevant. This doesn't change the outcome of the trial. She did not argue once, though, that Hannah's own interviews were some of the strongest evidence here, which was interesting. It was more defensive than that. And it was, they knew, they should have known, they could have known. And yes, the things we did suppress were after discovered, but even then she doesn't get a new trial. The court said that she was going to rule early next week. So we will see a ruling early next week. Maybe, I don't know, Tuesday, Wednesday, maybe. I think that's early next week. But she said early next week, but next week for sure. And the court will rule on both the motion to dismiss as a sanction for prosecutorial misconduct and because of after discovered evidence and for Brady violations. And she will rule on the motion to release Hannah Gutierrez. I'm very interested to see what will happen. The court did not give a lot of feedback in this. It was, Bowles, and then she let him argue. Prosecution, and then she let her argue. Reply, and that was about it. Thank you. I'll rule next week. It was a very limited interaction from the court. So I can't wait to see what her written ruling is, because her written ruling in the Baldwin case was fiery. So will Hannah's case get dismissed? Will she get a new trial? It's possible here. The amount of evidence that was not turned over is substantial, and Seth Kinney is a fairly important witness, I think, to the case. So not turning over a video recorded interview until after trial is fairly substantial in my mind. So we'll see what the court does. And I can't believe what a mess this special prosecutor has made of these prosecutions. There's absolutely no reason it should have been this messy. And it is. And I think that doesn't do justice to Helena Hutchins, to her family, and truly to the entire movie industry that wants to see where the boundaries are of safety on set. This mess has become a sideshow of a case that is serious, that should never have happened and should have been treated with some level of seriousness, and has turned into a Brady violation shit show. And it's not how our justice system should ever operate. And that level of Brady violation should not be allowed to stand without some sanction. I'm curious to see what the court decides that sanction will be. All right. Chat, have all of you noticed that I've gotten better at doing those? It makes the quick bits go better. It makes the quick bits go better when we can do a good summary for the quick bits. So for all of you that are quick bits fans, we're doing better. We're doing better. All right. I'm going to do some Q&A real quick. Then we're going to take a lunch break. Then we will be back here in a second stream for the Kohberger case. Hey, Miguelina, do you want to put up just a live court stream for Kohberger? Like live court hearing at 3 p.m. and then I'll update the thumbnail. We'll just use like whatever the standard biddly bobber is. And I should do a Q&A bumper. I swooped and then I old swooped, I new swooped, and we're going to fack around. All right. So I am going to answer some of our questions and then we are going to zoom. There's also some celebrations in the chat. So we're going to take a moment to celebrate. But like all things, first in mind, I thought this was a great question. Digital Maven, thank you for the question in the super chat. Thoughts on why the actual DA in the county has not taken her off the cases yet? I do have thoughts. Based on prosecutorial misconduct included in the orders, don't understand why the New Mexico DA office hasn't intervened. A little while ago, hold on, let me find it. I just saw this morning. DA's office. There was a statement, I think in Variety. And I will look at what the statement is, and then we will talk about it a little more. This is from July 15th, so it is a little bit older, to be fair. But this was after the Baldwin case got yeeted right out of court. So let's take a quick look at what the New Mexico DA said then. DA affirms support for Rust prosecutor after Baldwin case tossed. The district attorney in Santa Fe, New Mexico, has affirmed her support for Rust prosecutor Carrie Morrissey after the manslaughter case against Baldwin was dismissed Friday due to withheld evidence. I mean, she knew this shit. Morrissey remains in her role as special prosecutor, handling 2 cases against Hannah Gutierrez Reed, the Rust armorer who was convicted of manslaughter in March. I mean, I think involuntary manslaughter needs to go in front of that. I think involuntary is a key component of this case, and is now serving 18 months. Morrissey, a private attorney, was appointed by the DA in March 2023. Let's see. The first judicial district attorney, Mary Altwies, said there is no better advocate than Carrie Morrissey to see the Hannah Gutierrez Reed case through, and her appointment and oath are still in place. So the elected DA has said, this is the best person to do the job, and we are going to continue on. Though a number of you in the chat have said what I'm thinking. They've paid her, but if I were a DA in the first district New Mexico DA's office, and my boss came and knocked on my door, hey, I know you're busy. That's how all of those conversations start. I know you're busy, but I've got a case I'm going to need you to handle. I don't know if you've seen anything about this Hannah Gutierrez Baldwin Rust stuff, but I'm going to need you to go in there and handle it. My immediate response would be, no. Nope. Go find a supervisor. Go find a supervisor. There are so many allegations of prosecutorial misconduct and stuff that wasn't turned over. Somebody else has made this bed, and I'm not lying in it. They're going to lie in it. I am not going down with this ship. Let the person who made the bed lie in it. So they need to go down with the ship. I'm not going down with that ship. That is not my fucking ship. I didn't build the ship. I didn't navigate the ship. I am not going down with the ship. Nope. Fuck no. Absolutely not. Absolutely not. Absolutely not. I think it's the DA preserving the deputies in her office. I don't think you can put a prosecutor into this place. I think you've got to deal with you've got to reap what you sow on this one. And so I think that's why they haven't removed her. And a number of you also said she's already been paid. She's already been paid. She's already been paid. Like that's miss me with that bus. And I have cleaned up some shit. I'm sure my coworkers have cleaned up some of my shit. Like, hey, I know you like tore your ACL last night and you're out and this case is supposed to go to trial. Can you just show me where all the subpoenas are? Do you have the file at your house? Like, what's going on? Coworkers cover by grabbing cases for each other. And there are levels of things that you deal with. I once got a homicide case that didn't have a note in the file for like a year and a half. And I was like, anyone want to tell me what the fuck's been happening? I can't tell. But that is much more bookkeeping matters of like, I can call up the other DA and be like, can you tell me what everything that's happened on this case? Do you have like a Word document that I'm not aware of? That is not dealing with wild levels of suppressed evidence where she's sitting in court going, yes, that was suppressed. Yep, that too. And it's not like one thing. It's like report after report, video. It's staggering. So no, I don't think you can even give this to anybody else because then they get looped in to the shit. Look, Carrie gets to wallow in her own pen on this one. We need a "This Fuckery Cannot Stand" t-shirt. Redondo Beach, A, how's the weather? How's the weather in my old home? And B, I like that suggestion. I like that suggestion a lot. I like it a lot. Basking in it said, will the judge's decision include Carrie's recent motion for the Baldwin case? No. Or does she have to stick to Hannah Gutierrez? Yes. She has to stick to Hannah Gutierrez. However, the way that it overlaps with Baldwin is how things were discovered. And that's very much a part of the record. So she can use that record. And some of that record overlaps. So where there is record made about Carrie saying in the Baldwin case, yes, this was suppressed, then that can come in because it was cited in these motions. So there is a little bit of overlap, but only as to the things that were briefed in this motion, if that makes sense. Let's see. Luna said, I got a promotion at work with a really good raise. Congratulations, Luna. We have lots to celebrate in the chat today. I love celebration days. Some days are harder. Some days there is a lot of challenge, but there's a lot of celebration going on in the chat. Sarah's also celebrating, just graduated as a doctor in medicine. Thank you, Emily, for body doubling and being my companion during long study hours. You're welcome. You're welcome. You're welcome. Look, whatever you're getting done, I am here to body double with you. So Sarah, Doc, congratulations. Hold on. That's a goat scream. We don't want to do a goat scream. Where are the applause? There we go. Give it up for Sarah. Congratulations. There were some other congratulations. Casey Cat said, can you cover her jail calls for those in the back that missed them? I covered them when we talked about her sentencing. They were in the motions. They were just text. We did not play them. We cannot hear them, but it was a little bit cold, little bit calculating of like, well, this is how we'll get around these gun restrictions. And prison is great. And, it was really annoying to like not supposed to be allowed to drink when I was doing this and that. So all those types of things. Kristen, I feel like chat, I might owe you a YouTuber style apology. So let me get into parody YouTuber apology mode. To all of you in the chat that appreciated our sponsor on Tuesday. And we love having stream sponsors. It allows us to have minimal advertising interruptions and allows us to keep growing Team Baker and bringing you more and more content, even when Emily is tired. Our sponsors go directly into, well, mostly bringing you quick bits and making sure that all gets edited down and I still sleep. So for all of you who have found yourselves deep down into the merge-tasticness that is Midas Merge, sorry, not sorry. It is a lot of fun. And there was a day that my hand started cramping because I held my phone so long playing it. So it is. I will say that for those of you that pointed out to me that there is a slot action component, for those of you that does not work for, just know that it is a merge game, but it also has some of that action that you need to play. It's free to play, but there is some of that slot action in it. So my ukulele is not in my office at the moment. I apologize. And for not having my ukulele to apologize appropriately, I also would like to apologize. Angelinos, any of you listen to the Heidi, Frosty, and Frank show like 100 million years ago when they did apologies at the end of every show? Those are my favorite. They're like, we would like to apologize to everyone that we have offended with this show, and then would continue to offend with the apologies. It was absolutely my favorite. Would those hold up in 2024? I don't know, but it was so much fun. It's like, I would like to apologize for everyone who has lost productive time and not done their laundry because they have been playing Midas Merge. To you, we apologize. So did Bill Handel do that too? I don't remember that. I vividly remember Heidi, Frosty, and Frank doing the apologies. Because I love morning radio. I did 2 morning radio shows this morning. Toadette said, I feel like I'm being lectured by my teacher every time Carrie Morrissey talks. Every time Carrie Morrissey talks. I definitely feel like she's going to say, I'm just disappointed. Like, One Nippy Hippie said, shout out to my husband who just got a new job. Congratulations to husband who just got a new job. That's very exciting. My husband keeps just spending more time at job that he loves. And I'm like, husband, we have things to do. But he loves it. Amanda said, recovering from a thyroid biopsy. Yay for court. Glad you're here. I don't know if that hurts, but don't yell at the screen. I'll do it for you. I yell at the screen for you. B2, thank you so much for the gifted membership. I appreciate it so much. I saw a few of you lamenting the easy ticket buying for Metallica. Yes, it's definitely different. I feel like for all of you that tried to buy tickets to, have Oasis tickets gone on sale yet? I mean, I feel like that's going to be a nightmare. The Swift ticket situation, nightmare. I'm sorry. Nebraska Jeff asked this earlier. I responded a little in the chat, but wanted to respond to this. How has Morrissey not been suspended pending investigation yet? That doesn't typically happen with the bar. If there will be full process before there could or would be any bar discipline. And that discipline can be everything from take a class to suspend your license is suspended for a set period of time to disbarment. I don't think disbarment would happen in this case. She is already on a Brady list. So whatever the state bar is or is not doing, that process takes time. They do not comment on whether an investigation is open or not. And if someone is disciplined, that is then down the road made public. Let's see. So I'm going to continue on. Team KK said, shout out to my sister Laura, who showed me this channel, sending lots of love because it's been a difficult week for her. I love the family chats. I love that you guys shout out your friends and family. It's completely one of the best things about this community. I love it. Casey Cat said, for everyone facing a Midas Merge addiction. There will be a Midas Merge meeting immediately after today's stream. You're welcome to discuss in the stream. I'm glad you guys are enjoying it. Orchid623 said, been watching since Step V Heard. Love you. Thank you. Glad you are here. Appreciate you guys. I love it. Where was this guy during trial? Heather, I think we talked about that a little, but yes, the way he argues motions is a bit different, but then we saw a little Bowles when he forgot to attach the Erlinda Johnson affidavit. I don't know if he'll file an amendment, but maybe he will. Maybe he won't. Susan, thank you for the 5 gifted memberships. It's always good to see you guys when you get back onto a stream to say hello. I know that life gets busy, and so there's some up and down about when you can be on stream, but it's great. Just because said, if Troy Teske is a former judge and law enforcement officer, shouldn't he have been aware of the timeline required for such testing and should have pushed Bowles? I think the prosecution said, we'll pick him up. And he was like, okay, I just figure you'll take care of it. So I think he was just like, all right, I'll let the prosecution get back to me. And then Morrissey was the prosecution. Octo, glad to hear that you've landed safely. Yay. Steven said, 1 terabyte rookie numbers, ask the Koberger attorneys. Right? Can you imagine the Koberger prosecutors being like, well, it's in there somewhere. Oh. Liz B said, Carrie really likes the sound of her own voice. I mean, I guess somebody's got to. Emily, that was too snarky. Mary asked for a poll. We did do a poll on who was better at reading the room. And I think Lally beat Carrie at who was better than reading the room by like a hair, but maybe we'll do another one. maybe we'll do another one at the end of today, because we've got lots of lots of court to do today. I love how Judge Summers is reacting right now. Yes, Judge Summers' face just didn't move. Reply. I don't have that kind of a face. My face does things. My face does things. I could never be a judge. Could just never. Could just never. So Rachel said hello from vacay in Italy. I mean, have the best time, Rachel. Thank you for tuning in, but also go enjoy Italy. Play some Pokemon. I mean, Pokemon Go and traveling is such a delight. It's such a delight. My biggest regret from Creator Summit New York is that we did not get to go play Pokemon Go. There was not enough time for Caleb from the Fitness Marshal and I to get out and play Pokemon Go. Massive regret. Huge regret. Big, huge, massive. Next time, we're like, okay, next time we're doing this. So that's the plan. All right. So many cute Lawnard faces in the chat today. I mean, the Lawnards are keeping it demure even when they were losing their minds over these arguments from Carrie Morrissey. Because absolutely. Oh, Jen, I appreciate you pointing it out. Good to see you. Ice Ice Baby said, love your mea culpa. Enjoy Metallica. We won a few years ago. It was rad. Jen, I appreciate you pointing it out, because again, we don't know what we don't know. And my neurospicy brain sometimes doesn't know what I do know. And that's an adventure daily. I talked about it on Tuesday with rereading the same book series, because I'm like, oh, I forgot that happened. There's times I just tune out. So let's see. Trophy Wife said, my nephew was convicted of bank robbery, was out 6 months when court threw out his conviction. Guards took letters with his lawyers to match handwriting. Interesting. I'm curious as to how the rest of that, like, I'm sure there's more there. If it was a wrongful conviction, I'm absolutely glad it got thrown out. But being out for 6 months before the conviction gets thrown out is incredibly frustrating, because you've served your time. So, hi, Emily. Loved your story about meeting new kids. Melanie, it was a lot of fun. And getting to do this job has opened up quite a lot of really cool opportunities. But I get to talk to you guys about the nerdy stuff that I love all the time. And that is a joy. We will have some programming disruptions as I get into the earlier bit of October, because my kiddo has the opportunity to tour some colleges. I'll keep you posted here and in the app. I will let you know on what we're doing as we finalize things. Asking me to finalize travel plans is like asking me to cut off a finger. I don't know why it's the hardest thing for me. People are like, Emily, a travel agent can do it. I'm like, right. But this is where like ADHD, decision fatigue, and like control issues come to play. No, I must do it on my own. And then sometimes when I do it in advance, it just doesn't work out either. So one never knows. Life is an adventure. All we can do is, make the best decisions we can in the time that we have. So Grassfolk said, loved you on the Vial Files. I hope it becomes a regular bit. Nick and I get along quite well. I'm sure we will talk other law and pop culture stuff. I will absolutely wear a hat next time before I wear over-the-ear headphones, or I'll just wear my in-ears, because I do not love the way I look in headphones. Also, I love streaming from leaving to go stream somewhere else when I do not have control is also very stressful for me. But I was like, we're going to embrace adventure and say yes. So for all of you that are like, Emily, you look uncomfortable at the beginning of that. Yeah, I left my house. It makes me anxious. But I sometimes lean into it, and you can tell. It's like, yes, I can tell. It feels uncomfy, but we do it anyway. And then we just go, see, we didn't die. We did something out of our comfort zone. But I love having a good chat about all things pop culture. So, and I know a lot of you understand when we do something new. I am so much better if I've done something before. The first time, so difficult. Second time, so much better. My team gets this. When we travel together, there are certain things we do every time we travel. And I don't know if this is just a neurospicy thing, because I've never been not neurospicy, but it's like, oh, this restaurant that we love, we're going there every time we're together. Oh, this is the exact meal we got last year when we were at this place, doing it again. Oh, what do we do when we go to VidCon? The first night we were at VidCon, we go to this restaurant. Day 2, we go to lunch here. Like, the routine of it makes me so much less anxious. So the first time it's hard. And then after that, it gets better. And it's like, oh, what are we doing today? Something new? No. No. We're going to the same restaurant we always go to. Don't worry, Warren, we're going to go to Frothy Monkey and get lattes. Promise. So no, we're going to go to the same places that we've gone before because we love them. Comfort. It's like we have a handful of rotations. It's like, do you want to try something new? I do, but my brain doesn't. So I need like a tour guide, like somebody who's like, oh, I've been to this place and I love it. Come with me. Much better. If I have to explore new things, oh my God, it's so stressful. I will say though, as we were looking around for what we were doing to go tour colleges, we did stumble across the fact that there is, in fact, a Bass Pro Shop hotel that exists. So I'll keep you posted about whether or not I decide that that's an adventure that I need to take. So law nerds, okay. We have done the things, we've answered the questions. I will be back here at 3 p.m. Central. I intend to be very much close to being on time. Cheers. So I intend to be very much close to being on time. I don't think it will be a long hearing. I think we're going to see a orientation with the new judge. And there's a couple little motions pending, like allowing the defendant to be in street clothes, which I'm sure they will, and things like that. So I imagine it will be a pretty quick, like, where are we? What's outstanding? Not substantive motions, but a pretty quick lay of the land hearing. Like, hey, everybody, this can't be an email. We need to all get into the same place and really have a chat. And the court is going to be streaming that. So we are going to see our new judge today for the first time in the Koberger case. So I'll be back with you live at 3 p.m. Central. Make sure you have the Law Nerd app. I'll ping you in case you get off and away doing things. Turn on your notifications and then you won't miss a thing. And I will ping you and we will be live again. So live again this afternoon. And then I will not be live probably until Thursday. I don't think I will not be live on Tuesday, but I will have a new podcast for you and a new Quick Bits for you. So we'll do all the things. Law nerds, I'll see you in a little bit this afternoon, okay? All right. Cheers. See you back here soon. Go get lunch. Hydrate.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.